world. My name is Chili DeCastro. Today is June 11th, 2024. I'm a journalist who's been unlawfully and unjustly locked up in the Clark County Detention Center in Las Vegas, Nevada. I've been charged with obstruction and found guilty by a biased, unprincipled judge who was married to a cop. It was the perfect trifecta. My lawyer didn't do a very good job. I had a bad day. I called the bailiff a pig, and the judge was biased, has been watching my YouTube channel, and she put me in jail for 6 months. I'm 3 months in. We are right now 4 weeks away, 4 weeks and a day away from the appeal. Today's daily journalistic update is covering a case called Wilson versus First Judicial District Court of Nevada, February 8th, 2024. The case is based on a March 25th, 2021 arrest of Lena Wilson, Willson, when Sergeant Mike Cullen was called out to a scene where a juvenile teen was threatening to kill himself. Lena Wilson went out to her front yard and started to scream at the police. The police later would arrest her and charge her with obstruction. That's the short version of the story. If you want to read more, I'll have the editor put the full story up on the screen so you can read it. But now when I get to page 10 of the LexisNexis, she was found guilty by the court, and then it went to district court. They upheld her conviction, and then it went to the Nevada State Supreme Court. Now, I have an appeal in the district court, July 10th, 2024, and so this is for the general public and any court officials who may want to listen to this. We have already had this exact obstruction case be heard in Wilson versus First Judicial Court of Nevada. And here's what it says on page 10. With respect to NRS Code 197.190 about obstruction, special intent would require that a person intended for a public officer to be hindered, delayed, or obstructed by the person's act. Now, that's what they charged me with, was obstruction. However, when I went on the scene in both of my cases, or I'm charged with obstruction, I announced that I was a member of the press and I was there to film them. In the second case specifically, I invoked my First Amendment right in the first 1 minute of interacting with the police. In the case that I'm in jail for now, unjustly, I also told them I'm a First Amendment auditor. It says here again, let me read it again for you. Specific intent would be required for a person to intend for a public officer to be hindered, delayed, or obstructed. That was not my intent. My intent was to be obstructed by the person's act, whereas general intent would require only that a person intended to perform an act that results in the hindrance, delay, or obstruction of a public officer, regardless of whether the person desired such a result. Now, there's more. Inside of this Wilson case, there's about 8 paragraphs that my lawyer can read at the district court to Judge Michelle Levitt and to the court. This case has already been heard in district courts. They found Lena Wilson guilty. It went to the Nevada State Supreme Court, and here's what they wrote in another one. Because the term willfully may also suggest an evil or malicious purpose on the part of the actor, and the terms hinder, delay, and obstruct are transitive verbs that require a specific object, any public officer, the phrase willfully hinder, delay, or obstruct any public officer may also reasonably be interpreted as requiring that a person intended for their act to hinder, delay, or obstruct a public officer. Well, I already announced that I was the First Amendment auditor and I was a member of the press. So it wasn't my intent to hinder, delay, or obstruct. It was my intent to be a member of the press. Continue on page 11. It says here, holding common law offense requires that the defendant intended his or her conduct and intended the harmful consequences of the conduct, and that is the interference with, obstruction, or hindrance of. Thus, to the extent that there is guidance from the other jurisdiction, it tends to lean towards interpreting the statute as requiring specific intent indeed. In other words, I would have had to have specific intent to hinder, delay, or obstruct, which I did not. I clearly stated I was a member of the press. Once again, I'm in jail for no good reason. It's completely absurd that I'm here. On page 12 of the LexisNexis of Wilson versus First Judicial Court, it says here, NRS 197.190, as required only as a general intent to act, would raise grave doubts as to the statute's constitutionality. In particular, such an interpretation would criminalize the significant amount of constitutionally protected activity, like being a member exercising, questioning an officer while he's performing his duty could constitute an unlawful act. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. This applies to both the case I'm in jail for now, unjustly and unprincipled, and this applies to my second obstruction case that comes up on June 24th. 4 paragraphs down on the left side column of page 12 of 17, it again states here, stating that determination whether someone held a belief had an intent is a true or false determination, not a subjective judgment, such as whether the conduct is annoying. United States versus Williams, as you know, is in the trifold. Therefore, we interpret NRS 197.190 as requiring that a person have the specific intent to hinder, delay, or obstruct a police officer in the discharge of their official capacities or duties. I did not have that specific intent. My specific intent was only to film police. NRS 197.190 only applies to physical conduct and fighting words. I hope that the court of Nevada, I hope the District Court of Nevada hears these words. This case has already been appealed to the District Court, and they denied Wilson's appeal. It went to the Nevada State Supreme Court, and they overruled it. So that means, this is my lawyer's argument right here, a First Amendment protected activity cannot be criminalized. You can't criminalize it because you don't like me or you find me annoying. I don't care. I will stand on my rights like it's home plate in Yankee Stadium. They're my rights, and I will not back down for them. Now, NRS Code 197.190 may reasonably interpret it as prohibiting speech that hinders, delays, or obstructs a public officer. You see that? It's unconstitutional. You can't do it. Now, here's the big ones. Here's the ones I circled that are on page 13 of LexisNexis right here. Page 13, 2 paragraphs down, HN 17. In light of the constitutional concerns previously identified, the canon of constitutional avoidance obligates this court to further limit NRS Code 197.190 application to physical conduct and unprotected fighting words. In other words, it's limited. I have to physically get in the way of the police or violently threaten them with words. Like, I'm going to beat the shit out of you, I'm going to fight you. Those are fighting words. You can't say things like that, which I didn't. It continues on the second column, page 13, third paragraph down. A statute that made it a crime to willfully resist, delay, or obstruct a police officer requires the presence of some physical act or exertion against the officer, which I did not exhibit. As a matter of fact, in the second arrest, I was walking away and they started pushing me so fast I couldn't keep up, and I had to stop and say, stop pushing me. They exhibited it. Now, the bottom paragraph, right-hand side, page 13 of 17 on LexisNexis, it says here, HN 18. Therefore, we, the Nevada State Supreme Court, interpret NRS 197.190 as applying only to physical conduct and fighting words. We note that obstruction does not require the use of force or violence, and that a person's actions blocking the path of an officer or inaction refusing to obey a lawful order may constitute a physical conduct that hinders, delays, or obstructs an officer, which I did not do. I did not do that. Finally, page 14 of LexisNexis right here. Left column, last paragraph, HN 20. However, as constructed by this court, NRS 197.190 does not apply to protected speech. It applies only to physical conduct and fighting words. You locked me up in the face of Wilson just being passed February 8th, 2024. The Nevada State Supreme Court clearly outlined the exact standards for obstruction. I'm rightfully indignant. I've been locked up in this God-blessed dungeon for 3 months, and I tell you what, when I get out of here, I'm going to shake the bitterness and the disgust and the indignity that I've been treated with. I'm going to check it off my shoes, and I'm going to walk out of here, and I'm going to turn around, and I'm going to sue the shit out of you. You had no right to put me in jail. Wilson clearly establishes that I did not obstruct, delay, or hinder any public officer in any way, shape, or form. Now, I'm going to put the entire thing up, all right? I'm going to put it on my website. You know what? I'll just have the editor put it in there. I sat up all night reading this entire case over and over and over. It's only 18 pages. Pretty easy read. I could keep going. There's more stuff stuff I outlined here that I could keep reading. But I just wanted you guys to understand that this county, Clark County, you're going to have to pay me. You didn't have any right to lock me up.
You've had the opportunity to watch the trial and the video, both of you. What were your initial impressions?
So initially, I thought the arrest should have never occurred. I think that he was not obstructing. And I think it will be interesting to see what Judge Levitt does with it on appeal. I think that he has created some interesting issues with his courtroom antics and post-conviction behavior, but his behavior on the day, at the time, the filming at the traffic stop, I don't think it rises to the level of obstruction.
What's an officer to do, though, when they've got somebody who is in their face and confrontational? And we can agree, Mr. DeCastro seemed to be somewhat confrontational, right? Go back and do your job, little doggy.
Sure.
Those kind of comments.
But first I want to address the comment in your face. Is 10 feet really in your face? The court record indicates that he was 10 feet away. Is that in your face?
It's a good question. How close is too close?
So first of all, I want to say that, my views are just mine. I do teach a lot of agencies here, and this issue is still being litigated, and one of my clients is involved in this case. But I will say this, is that this is a tough situation. I mean, these police officers are tasked with a very tough job, and, officer safety is a legitimate safety concern. But we also don't want to, hyperbole, right? We don't want to think that everybody is out there to kill us. That's not a good mindset either. That's actually a very unhealthy mindset. How close is too much? I will say at the end of the day, what I teach my officers is that when it comes to obstruction is that you basically cannot effectively do your job. And I compare that with efficiently, right? A lot of these First Amendment auditors will do things where it causes you cannot efficiently do your job. You have to, talk a little louder. You have to, maybe, take your attention away and maybe address them for a little bit. That's not so efficient, but it's also maybe not illegal. I'm not saying we haven't really gotten to the brass tacks of what Jose's done in this case, but I'm just saying that's generally speaking, how close is too close? The officer, what I teach and my principles is that the officer cannot effectively do their job.
And you say First Amendment auditor. What is a First Amendment auditor? This is a newer term. I mean, I've done this job for 30 years.
Yeah.
This is the first time I've heard that. Maybe I need to be more in tune with social media.
So interestingly, in preparation for us to have this discussion, did a quick little, search on Google to see, because there are lots of definitions for that phrase, because it is a relatively new phrase. And there are two prevalent internet definitions for what is being defined as a First Amendment auditor. One is exactly the behavior that Mr. DeCastro is engaging in, those that pull out their phones and record police activity. And another is people who pull out their phones and record activity in any public space. So it goes beyond that of just police activity. But if I walk into a commercial business and I pull out my phone and start recording interactions between a patron and a customer, if the employee at that business calls the police on me, they have failed essentially that First Amendment audit, because the argument is that you should be able to record any interaction in any public space. And that puts us down a completely different rabbit hole than from today's conversation. But I thought it was an interesting point of view, because it kind of ties into, I think, Mr. DeCastro's point of view and where he was at when he was recording the police interaction in the traffic stop.
So is the position of these folks that in public spaces there is no privacy?
Essentially, yes.
Generally.
That's the idea, and particularly with officers. Of course, officers have body cam now, too.
So they're recording themselves. But I would also say, just before we go on to that, because I think that there are actually two types of First Amendment auditors. There's the first 1A auditor who want to be cool about it, The first 1A auditor is those who just want to record. They just want to see police officers. They're actually hoping for a good outcome. They're hoping that the Constitution is complied with. And then there's the other First Amendment auditor who's like DeCastro, who is really after three things: money, badges, and fame. They don't want to just watch cops succeed. They want to watch cops fail. And the way he acts, what he says, the words he uses, go back to your job, little doggy, whatever, Right. I mean, he says all kinds of things. He does not want to see cops succeed. He actually makes it very clear that he is very anti-police. And I just want to be clear that that's something to consider. But generally speaking, it's not illegal to record police officers in a public place doing a public act.
Or to be anti-police.
Or not to be anti-police. Absolutely. He absolutely has the right to be anti-police. Absolutely. And he has the right to say that during his presence.
But in this situation, there's no question he's antagonistic.
Correct.
Right? He doesn't want to back down. He's at another arrest where he was also antagonistic.
Right.
Told an officer, "Shut your mouth. I'm an important guy.
Right.
I'm on YouTube, and you're going to look like a fool. Just shut your mouth and mind your own business if you know what's good for you."
Right.
I mean, he is clearly antagonistic.
And he's good. He's very good at it, by the way. If you watch his videos, he's highly effective. He's sharp when it comes to this antagonism.
Being antagonistic doesn't always rise to the level of being a crime. I mean, in this case, I realize that argument sounds ridiculous because he was arrested and now sentenced for obstruction. But had he been 20 feet back, would we be having this conversation?
I think the key, though, is it's not that he's committing a crime by being antagonistic. I think it's that you have an officer who is allowed to consider his antagonism. He's allowed to consider that this person clearly does not either see me as a legitimate authority or whatever, and he's allowed to consider that part of his officer safety issue.
Understood, but in this instance, part of this is whether or not you're stopping an officer from doing his job, right?
Mm-hmm.
That's part of the
I think so,
part of the fundamental definition I would think of obstructing. And in this instance, before DeCastro is ordered to go to the police car, he lets the motorist go.
Right.
His job is done at that point. And the resisting's about the walking to the police car, which DeCastro's doing. He's disgruntled about it, but he is doing it. I'm a little, it seems like we're having it both ways to some extent, if that makes sense.
The only thing I will say about this, and I love your point of view on this, is that at the end of the day, if we believe that a crime has already occurred, that he's already obstructed, which we can debate about that, then he's allowed to now have discretion. So you know what? I have a bigger fish. You're my small fish. You were just committing a very minor traffic violation. In fact, it was like registration issue. You're out of here. Now I'm going to deal with him.
Sure, but what would the normal everyday obstructing, would it always result in an arrest?
No.
It's discretionary, right? So many years ago, I had a case that was kind of similar to this, where it was a traffic stop and it was a sovereign citizen case, which again, another rabbit hole, but officer asked my client for a driver's license. He didn't have it because he had a constitutional driver's license, and it led to an obstruction and a resisting charge because my client couldn't produce a driver's license. And so ultimately, as my client was shuffling through these papers trying to find his constitutional driver's license, the officer felt like he wasn't complying with the command fast enough and ultimately pulled my client out of the car, which led to the obstructing and the resisting charge. So in my mind, I don't think there's much of a difference between my client attempting to produce his constitutional driver's license and what Mr. DeCastro was doing in this case. He was standing 10 feet away, yelling obscenities at an officer. By the time he got to the point where he was walking to the car, we have compliance.
You have a biased and unprincipled judge, Ann Zimmerman, who put me in jail because she loves cops. She even said to me, "You hate cops, well, we'll see about that." And then she put me in jail. Then when I went to my appeal bond hearing, she said, "Have you seen his YouTube videos? Have you seen what he's saying?" Meaning she went outside the scope of the case. That's not right. It violates judicial canon number 1 of the Nevada state constitution. She cannot do that. She's violated my rights, and Clark County, you're going to have to pay me for this now. It should be in the millions of dollars for locking me up like this. This is absurd. This is absurd beyond the pale. So, all right, let me do this. Let me take a breath here. Let me calm down. Let me talk to my people here. Let me talk to my people, all right? When you read this case, when you read Wilson versus First Judicial District Court, and it had to go to it is just so unbelievable that I've been in jail for this long. And this case was just decided February 8th, 2024, and that biased, unprincipled judge did this. Well, sorry, Nevada taxpayers, but I'm going to sue. Okay, so there's only 2 more paragraphs I want to read here on page 16 and 17, 16 of 17 and 17 of 17, and this is for the court coming up for my appeal on July 10th. It says here, the district court did not have the benefit of our interpretation of the Nevada State Supreme Court as being limited to physical conduct and fighting words, and it therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or uttered fighting words so as to support her conviction of of violating 197.190. And then on the last page of page 17 or 17, the very last paragraph, HN 29, for the reasons discussed above, we conclude that NRS 197.190 only applies to physical conduct and fighting words that are specifically intended to hinder, delay, or obstruct a public officer, and thus the statute is not unconstitutionally overbroad or vague, either on its face or applied to Wilson. However, in light of our interpretation, Wilson's as-applied constitutional challenges are more properly viewed as challenges to the sufficiency of the evidence. Because the district court did not consider whether there was sufficient evidence to support Wilson's conviction, we grant the petition and direct the clerk of the court to issue a writ of certiorari upholding the constitutionality of 197.190 and instruct the district court to reconsider Wilson's direct appeal for the sole purpose of addressing whether, under the court's interpretation of the statute, sufficient evidence supported Wilson's conviction. Overturned. Just like that. Just like that. How in the world am I in jail right now when Wilson exists? It's so unbelievably preposterous. I'm not going to carry this burden with me. I'm not going to carry this resentment with me. I'm going to get out of here, and I'm going to sue Clark County. And I'm going to sue that judge, and I'm going to sue that bailiff, and I'm going to get those cops' pensions for arresting me. You guys lose your qualified immunity. All of you do. And the judge loses her qualified immunity as well for illegally searching me before the trial began. Let's see what happens when we go down the legal process, because I'm going to hire the best civil rights attorney in the country. I'm not going to go pro se. No. I'm going to hire the best civil rights attorney in the country to sue you bad people. That's the best way to put it. All right, so I'm fired up this morning because I read this all night long. I read it again, I read it again, and I read it again. So there it is. Now you know. Put it on your calendar. We are 4 weeks and 1 day away from the appeal. I don't know how Michelle Levitt can read Wilson for my appeal on July 10th and not overturn the conviction of obstruction. I clearly went there to film the police, clearly invoked my First Amendment right. And even still, I wasn't there to hinder, delay, or obstruct. I was there to film the cops' interaction. You cannot convict me of obstruction. It has to be a physical act or fighting words. I know I'm upset, I'm frustrated, but I'm in this frickin' dungeon. And so what you guys don't understand is that the guy who's in the front of this place, the guard of this room, of this dorm, of this bunk, of this pod, whatever you want to call it, that person dictates whether or not you have a decent day or whether your day totally sucks. Some of these guards come in here, and I'll be honest with you, some of these guys are pretty chill people. They're pretty laid back. They don't say much. There's a system here. It's a very simple system. Chow time is at this time. Med is at this time. Commissaries at this time. Commissaries tonight. So I'll get your eye care gifts packages for you guys who sent me up tonight. Really appreciate it if you did. Thank you. I mean, it's just, some of these guards come in here, they don't say much. You follow the system. Everybody gets up for chow at a certain time. You know, there's very specific time slots. Some of these guards come in here. They start screaming from the time they come in, and they're screaming from the time they leave. And it's just, I just don't understand it. You know, I don't understand why some people are so calm and so chill, and then other of these guys are screaming at us from the time they get here to the time they leave. I just don't understand just so wide variation. You know, I just don't get it. And there's other things, but I don't want to say anything, you know, other than that. And I'll just leave it at that because I can't really say anything right now. I've got to make sure that I stay safe in here. And I haven't been abused. I haven't been mistreated other than put in the hole for live streaming. So, but, you know, the dichotomy between my day, the up or down of my day, the positive or negative of my day, is all dependent on which guard walks in the door. And that's the way it is. Whether you like it or not, when there's someone screaming at you, you can't reply. You can't have a bad day in here. If I reply to the guard, I go to the hole. If the guard's yelling at me and it doesn't make any sense, you know what I say? You're right, sir. I was wrong. I should have known better. I mean, it's just, you can't in any way have a bad day in here. You got to be careful with the other people you're around. You have a negative interaction with one of these guys in here, any one of the 70 guys in this toddler thing, and they punch you, you're going to the hole. You lose your good time. So I'm in a system of chutes and ladders and pitfalls and pulleys and hooks and levers, and if I step the wrong way, it could cost me my life. Like, it's not a joke. This is very, very serious. And they put me in this place when Wilson exists. So to Team DLZ and to the faithful, God bless you. Thank you. I appreciate you. I love you. I will not stop until we change this system. I guarantee it. I have invented a new device to take the place of torture cuffs, to get rid of torture cuffs altogether. I've already sent it off to my lawyer to begin the patent process. So I'll let you go. Thanks for listening to my daily journalistic update. I really appreciate it. Like I said, my name is Chili DeCastro. Today's June 11th, 2024. We are 4 weeks and 1 day away from my appeal, and hopefully this case is overturned and I'm released on July 11th. Thank you for support. I'll see you on the next one. Later, Gators.